After almost 3 hours in deliberations, a jury has found defendant Darrell Brooks guilty of all 76 charges in the deadly parade crash trial.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 26th day of October 2022, signed by the foreperson, juror number 11. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. And I should state as to count 2, it was signed and dated by the foreperson, same as to count 3. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 4 of the information, dated this 26th day of October 2022, signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 5 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 6 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Brooks has been defending himself in court after he recklessly drove an SUV into the Waukesha Christmas parade last year, killing 6 people and injuring dozens more. For weeks, 3 weeks, we have watched Brooks consistently interrupt the proceedings with his random outbursts and be removed from the courtroom multiple times. Many, including the judge, Judge Darrell, suspect that the motions and objections made by Brooks in court were a ploy to stall the trial, which ultimately ended in his conviction. Still with us, we have our attorneys Rich Schoenstein and Jennifer Alcati. All right, I am very excited about this segment because I want to talk about some of these legalese used by the defendant and talk through them. So first, we're going to talk about Brooks because, as we know, he was a pro se defendant. So what does this mean? This means that he desired to represent himself without a lawyer allowed by the 6th Amendment of the Constitution, in Latin, for in one's own behalf, so he did this. Now, this was approved by the judge for him to represent himself pro se after deciding whether or not he was competent, because that's a decision the court first has to make. And competency is when a criminal defendant is able to participate in their defense and able to understand the nature of the proceedings against them. And if someone is incompetent, like Lori Vallow-Daybell, competency can be restored. So that's where we start with this case. Now I want to bring Rich, Jennifer into this conversation because I want to talk about motions. There were a number of motions made by this defendant in this case, and the definition of a motion: a request to a court for a desired ruling or an order, and a motion can be written or spoken. However, I'd like to first get from each of you, in your experience, Rich, let me start with you. Can a motion be written or spoken, or generally in the court in which you practice or are accustomed to, does it have to be written?
During trial, motions can be written or spoken. Before trial, they almost always have to be written. So they can be written or spoken, but if you have a serious motion, you want to put it in writing. You want to cite your case law. You want to put your reasoning in something in writing, because you're making a record so that if the trial judge doesn't agree with you, you can raise it on appeal. So you want to carefully, I mean, this is one of the 4,000 reasons it's such a terrible idea to represent yourself at trial. You're not competent sitting in your jail cell to write and research a legal motion.
But as I was watching, Rich, and then Jennifer, I'm going to bring you in for all of your thoughts and your expertise, because as I was watching Rich, I just felt like no matter what Darrell Brooks said, if he didn't like the response by the court, for instance, subject matter jurisdiction, then he would say, okay, I'm filing a motion, or I want this motion to be heard. Was he using motions appropriately, in your opinion?
Not really. He understood conceptually that he had to make a record. So he kept saying, you know, note my objection. He knew he had to preserve his arguments, but he didn't really know how to do it in a technical manner.
And that's part of it. All right, Jennifer, let me get your thoughts quickly on motions.
I agree with Rich entirely. I mean, I think something too that 90% of the motions that I draft are written motions. Typically in that motion, I'll request an oral argument if it's a matter that I believe is important to speak about in front of the judge. But I'll put that oral argument request in one of my motions. Now, if it's in trial, typically I'll just have those motions ready to go and prepared if there's, you know, a motion in limine or I need to exclude certain testimony or evidence from the record. But I do think, just like Rich said, it's really hard to do that briefing and that drafting if you don't have the proper tools to do so too. And without case law, you really can't make your case.
Right, absolutely. All right, let's go to another legalese that was thrown out there a lot, and that is the sovereign citizen. When a person believes he or she is not under the jurisdiction of the federal government, they can therefore consider themselves exempt from the United States laws. Jennifer, let me start with you, because we know that Darrell Brooks actually, let me get your thoughts, and then I want to listen to part of it of what Darrell Brooks thought about being a sovereign citizen.
So this actually really interested me because I've seen pro se defendants before, and interestingly enough, from the three that I've seen, all of them claimed the sovereign citizen argument. So I'm not sure if that's something that, you know, they Googled or they were told in jail that this is an argument you absolutely have to make or something. But it is an argument that I've seen be made a lot, which is very interesting to me.
It is interesting. Let's listen to a little bit of what was pulled. Thank you, Jasmine, for the reminder, because we have some of what he had to say about it.
A lot of the questions I ask are objected to. It seems like I can't even get to the questions that need to be answered.
Sir, many of your questions go to these sovereign ideas that are frivolous arguments about the plaintiff and all of that. We give you a little bit of leeway. I give you a little bit of leeway on it. But to ask about a claim, because frankly it's a vague question, and many of these victims may in fact have made a claim with crime victim compensation, and so I think that's potentially relevant, but you may be asking it for a different purpose. I'm allowing it probably for a different purpose than you're anticipating, but the questions about the state and the plaintiff, other than when you talk about and you ask questions about who subpoenaed them, have they reviewed anything in preparation for their testimony, those are all fair game. But other questions are not, and that's why there's an objection, and that's why I rule the way that I do.
You made reference to questions I asked, and you said something to the effect of sovereign things. I don't understand what you mean by that. I got enough work to do on the fly. I'm definitely not trying to sit here and trying to anticipate what will be objected to, what will be ruled on in any way. I'm merely just, it was understood that this would be a whole new thing for me to do.
Mr. Brooks, the jury's coming back in.
For the record, I don't consent to that name, and I don't consent to the arguments that the prosecution made. There are relevant questions, as the jury deserves
Mr. Brooks,
to know.
Please.
The jury deserves to know who the plaintiff is in this matter.
Another aspect of the sovereign citizens is they don't recognize their name, as he keeps saying. What are your thoughts on this issue?
Utter and complete nonsense. First of all, the idea that you can drive into a parade and murder 6 people and escape liability because you say you're a sovereign citizen, there's no precedent for that anywhere in the country. Secondly, he's talking out of both sides of his mouth. He has a driver's license. The driver's license says his name. He's lived his life as a citizen, and you, Judge, made the best point of all to me yesterday, sitting right here. He's espousing his constitutional rights continuously through this trial. What kind of sovereign citizen keeps relying on the Constitution to protect himself?
No, you're right. You're absolutely right. And again, nonsensical. I think a lot of these words and things he's been throwing out. Let's talk about another one. Darrell Brooks continued to throw out subject matter jurisdiction. So what even is that? That's the requirement that a given court has power to hear the specific kind of claim or issue that is brought before that particular court. Let's listen to Darrell Brooks.
I want to state for the record that I intend to appeal that judicial decision made about the motion to dismiss.
Noted for the record. All right, let's bring the jury out then.
Actually, we didn't address subject matter jurisdiction. It still has yet to be proven, for the record.
All right, Jennifer, what is he talking about? He kept bringing it up and kept bringing it up, and I don't even understand why he kept bringing it up.
To be honest, I don't understand why he kept bringing it up either. I think that he did pick a couple legalese terms that he just felt, okay, this will be able to preserve my argument, because if you don't have subject matter jurisdiction and you don't have personal jurisdiction and you don't have venue, then you would have to get the case transferred, right? So I think maybe his intent with it might have been that, okay, if I argue that there's no subject matter jurisdiction here, this case will take me to a different judge. Maybe he just didn't like the judge. That could have been one of his intents, but I really think he just kept sticking with some legal jargon that he knew and wanted to continue with it.
And you know, I think I could speak for all three of us when I say if any of us ended up in court for any reason, none of us would do it without a lawyer representing us. All right, subject matter jurisdiction, your thoughts?
Well, yeah, he drove on the street in Waukesha, Wisconsin. He is subjected to the jurisdiction of the court. That's it. Subject matter jurisdiction is, does the court have power over you? He's in that community driving. The court has power to regulate his conduct and to punish him if he commits a crime.
All right, we want to get to one more in the time that we have. A motion for jury nullification made by the defendant. What is jury nullification? It's when a jury finds a defendant not guilty in spite of finding the evidence proved guilt beyond a reasonable doubt. You mentioned it earlier, but bring it back around. Rich, is it allowed or not to tell a jury about jury nullification?
Absolutely not. You can never stand up as a lawyer or as a defendant and tell the jury that they should ignore the law. The judge spends an awful lot of time instructing the jury on what the law is and what they have to find, and you're not allowed to tell to the jury, just ignore that.
All right, jury, Jennifer, weigh in on this one. You have the same experience, not allowed, it's a no-no.
Agreed. I mean, like I said previously, the judge had so much patience. I mean, the decorum of the court is one of the most respected places to be. And the fact of the matter is, if you're going against the judge's orders and rulings, it is not a good look. It does not look good. It is disrespectful on so many levels. All around awful.
All right.